Okay, I just hit the button for everything to go live.
As we must.
Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County.
Buenos días a todos. Esta audiencia es su comparecencia inicial en la sala menor del Tribunal de Primera Instancias del Condado de Clayton.
My name is Brad Gardner, and I'm a judge in this court.
Yo soy el juez Brad Gardner. Soy un juez en este tribunal.
I am not here to conduct a trial of your case or to take a plea in your case.
No estoy aquí para llevar a cabo el juicio de su caso, tampoco para aceptar su declaración ante las acusaciones.
I am here to inform you of the charges that have been filed against you,
Estoy acá para informarle de las acusaciones formuladas en su contra,
to advise you of certain rights,
para informarle de ciertos derechos,
to set bail on those offenses that I'm authorized to set bail,
para imponerles fianza por los delitos los cuales tengo la autorización de imponer fianza,
to schedule a preliminary hearing,
para programar su audiencia preliminar
and to determine whether you require the assistance of an attorney.
y también para determinar si requieren el asesoramiento de un abogado.
You have the right to remain silent and say nothing.
Tienen el derecho a guardar silencio sin decir nada.
But should you give up this right, anything you say during this proceeding may be held against you if your case goes to trial.
Pero si eligen renunciar a ese derecho, cualquier cosa que diga durante esta audiencia se puede tomar en su contra durante cualquier audiencia o juicio.
So please don't discuss the facts of your case.
Así que les pido, por favor, no hablen de los detalles de su caso.
During this and all other proceedings, you have the following rights.
Durante esta diligencia y cualquier ulterior, tendrá el beneficio de los siguientes derechos:
The right to the presumption of innocence,
el derecho a ser presuntos inocentes,
the right to indictment by a grand jury for most felonies or by accusation for misdemeanors,
el derecho a ser acusado formalmente por el gran jurado cuando se trata de delitos graves o en el caso de delitos menores por acusación general,
the right to a speedy and public trial by jury,
el derecho a un juicio público y sin demora ante un jurado,
the right to see, hear, and question witnesses who are called to testify against you,
el derecho a ver, a escuchar y a interrogar a los testigos convocados a declarar en su contra,
the right to compel the attendance of witnesses to testify on your behalf,
el derecho a obligar que comparezcan testigos para que declaren a su favor,
the right to testify on your own behalf or offer evidence in your own defense,
el derecho a dar su propio testimonio en defensa propia o presentar pruebas en su propia defensa,
the right to have an attorney represent you.
el derecho a un abogado que lo represente.
If you cannot afford an attorney, one can be appointed to represent you if you qualify.
Y si no puede costear el gasto de un abogado, se le puede designar uno de oficio si cumple los requisitos.
Some of you will be allowed to post unrestricted bonds for your release from jail.
Alguno de ustedes se le permitirá depositar fianzas sin restricciones para salir de la cárcel.
These bonds may be posted by cash, commercial, or property.
Y la fianza se puede depositar en efectivo con una compañía de fianzas o con la garantía de un inmueble.
If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office.
Si usted va a depositar su fianza en efectivo, entonces alguien tendría que entregar el total de la fianza más las tarifas administrativas en la comisaría del sheriff.
The sheriff's office will hold the cash and return it at the end of the case.
La comisaría del sheriff guardará el dinero y lo devolverá cuando se concluya el caso.
If you use a commercial bonding company, someone will have to pay a fee to the company for their service.
En caso de utilizar una compañía comercial de fianzas, alguien tendrá que pagar una tarifa de servicio a tal compañía.
The fee will not be returned.
La tarifa no se devuelve.
I don't know what fee will be charged, but it is usually based upon a percentage of the bond.
No sé cuál es la tarifa exacta que le van a cobrar, pero normalmente se basa en un porcentaje de la fianza.
Finally, if you use property to post a bond, the property will need to have a net equity at least 3 times the total amount of the bond.
Por último, si va a usar un inmueble para garantizar su fianza, esa propiedad tiene que contar con un patrimonio neto de por lo menos 3 veces lo que es la fianza.
Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places.
Algunos de ustedes tendrán fianzas que conllevan condiciones especiales, las cuales prohíben contacto con ciertas personas o que vuelva a ciertos lugares.
This special condition will be provided to you on a separate form.
Las condiciones especiales se los van a proporcionar en un formulario separado.
You will also be prohibited from contacting the victim while you are in jail.
También se les prohíbe contactar a la víctima mientras están detenidos en la cárcel.
If you violate the court's order, your bond will be revoked and you can remain in jail until your trial.
Si incumplen esta orden judicial, su fianza quedará revocada y permanecerán detenidos en la cárcel hasta el juicio.
You could also receive additional felony charges.
También a consecuencia se le puede formular cargos adicionales de mayor cuantía.
It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond.
Cabe señalar que si una persona figura como víctima, en el caso de usted, a esa persona no se le va a permitir pagar la fianza.
Some of you are charged with offenses for which this court is not authorized by law to set bail.
Algunos de ustedes tienen acusaciones las cuales yo como juez no tengo la autorización de imponerles fianza.
In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date.
Si ese es su caso, una audiencia para determinar su fianza se programará ante un juez de la Sala Superior del Tribunal de Condado de Clayton y a usted le informaré de la fecha de tal audiencia.
If you are currently on active probation, this court is not authorized to set bond at this time.
Si actualmente está cumpliendo una condena de libertad condicional, no tengo la autorización de imponerles fianza en este momento.
Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest.
Una vez que su agente de libertad condicional ha tenido la oportunidad de considerar esta nueva detención, en ese momento se determinará si es apropiado imponerle fianza.
The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you.
El propósito de la audiencia preliminar es para determinar si existe suficientes pruebas para respaldar las acusaciones o fundamentar las acusaciones en su contra.
The standard at this stage is very low.
El estándar de lo que hay que probar en esta etapa jurídico es muy bajo.
A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred.
Para que un juez determine que un caso siga adelante en esta etapa judicial, solamente tiene que determinar si es posible que se perpetró el delito.
Everyone has the ability to waive their right to a preliminary hearing.
Todos tienen la habilidad de renunciar a la audiencia preliminar.
However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing.
Sin embargo, deberían consultar con un abogado primero para determinar si es apropiado en su caso renunciar a la audiencia preliminar.
If you post bond, your preliminary hearing is automatically waived.
Si depositan fianza, la audiencia preliminar queda renunciada automáticamente.
You will receive notice at the address you give of your next court date.
Y recibirá notificación de la próxima cita judicial en la dirección que dejan registrados.
Finally, I need everyone to raise your right hand.
Por último, necesitan que todos levanten la mano derecha.
You swear or affirm any testimony or you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God.
Juran o afirman que cualquier cosa que diga durante esta audiencia será la verdad y toda la verdad ante Dios lo juran.
Okay, let's start with Mr. Teles.
Muy bien, comenzamos con el señor Telles.
Mr. Teles, can you see and understand the interpreter?
Señor Telles, ¿puede usted oír y entender a la intérprete? Your Honor, may I ask him to repeat, please?
Yes, I didn't hear that response.
Como dice señor, no lo escuchamos bien.
No le escuché lo que me dijo.
I didn't hear what you asked me.
I'm sorry, Mr. Teles, can you see and understand the interpreter?
Perdón, señor Telles. Le pregunto que si usted puede oír y entender a la intérprete.
Sí,
Yes.
Sir, you've been charged with 1 count of driving under the influence,
Señora, usted se le acusa de una infracción de manejar bajo los efectos de alcohol,
1 count of driving on the wrong side of the road,
una infracción de manejar en el sentido contrario
and 1 count of driving a vehicle with no license.
y luego una infracción por manejar un vehículo sin licencia.
Your total bond is going to be set at $6,500. Can you pay that bond?
Se le impone la fianza total de $6,500. ¿Puede usted pagar la fianza y salir, señor?
no tengo con quién.
I don't have a way to.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer?
Está bien, señor. Quisiera entonces que yo determine si usted cumple requisitos para un abogado de oficio.
Sí,
Yes.
Are you currently working, Mr. Teles?
Señor Telles, ¿está trabajando actualmente, señor?
sí, yo trabajo en la construcción.
Yes, I work in construction.
Approximately how much do you make per hour?
¿Y aproximadamente cuánto está ganando a la hora?
Me pagan 150 al día.
I'm paid $150 a day.
I'm going to find that you qualify. I'm going to appoint a lawyer to represent you.
Determino entonces que usted sí cumple requisitos y le voy a designar un abogado de oficio.
You are going to have a preliminary hearing date set for July 27th at 8:30 in the morning.
Su audiencia, señor, su audiencia preliminar se señala para el 27 de julio a las 8:30 de la mañana.
That date will get waived upon your bonding out and you'll get a new court date in the mail.
Esta audiencia se renunciará una vez que deposita fianza para salir y luego le notificará de la próxima audiencia por correo.
I would encourage you to contact the bonding companies that are authorized to write bonds in this county.
Le exhorto que se comunique con las compañías de fianzas que tienen autorización para tramitar fianzas en este condado.
Tell them your name, your charges, and your bond amount.
Dígales su nombre, sus acusaciones y la cantidad de su fianza.
And see if they will work with you in order to make a bond.
Para ver si ellos pueden arreglar con usted y así puede conseguir una fianza.
Do you have any questions for me, Mr. Teles?
¿Tiene usted alguna pregunta para mí, señor Telles?
Ahorita no.
Not right now.
Pero ¿cuándo
Okay,
usted
sir.
¿cuándo podría salir?
But when would I be able to get out?
When you're able to post the bond.
Una vez que puede depositar la fianza.
You're going to have to take the steps necessary in order to be able to get out on bond.
Usted va a tener que tomar los pasos necesarios para poder salir bajo fianza.
Okay.
Okay.
Okay, sir, you're free to go back.
Muy bien, señor. Ya se puede retirar. Gracias.
Mr. Bailey, I'm sorry, Ms. Tolles, let's just ask, is there anyone else on the male or female side that need the services of the interpreter?
No on the female side, Your Honor.
Okay. Okay, Ms. Tolles, you are free to go. Thank you, ma'am.
Oh, I just wanted to ask, Your Honor, there was someone who was listed as a fugitive, and that person is...
Yes, let's see. I know who you're talking about. Let me see. Are you talking about Lopez Alvarez?
Yes, sir.
We dealt with him yesterday. He did need the services of an interpreter. but the detectives were down from New York to take him back on the fugitive warrant. So we added him on yesterday.
Yes, sir. Okay, thank you very much.
Okay, thank you, ma'am.
You all have a great day.
You too. Mr. Florio, how are you doing today, sir?
Good morning, Your Honor. How are you doing, Judge?
I'm doing well. I will tell you, and I meant to tell you and Mr. Schrade before about just the preliminary decisions that I made. For Mr. Bailey, I'm preliminarily I'm denying the bond on the felony criminal damage to property in the second degree. He was on bond at the time of this second offense. I placed him on bond back in February.
Yes,
So currently I placed a $5,000 bond on the hit and run and no bond on the criminal damage to property in the second degree. But of course, I'll hear from you at the appropriate time. Mr. Bailey, I would normally address you, sir, but you've hired a lawyer, Mr. Florio. So I'm going to address Mr. Florio. You should understand that any statements you make during this proceeding are not privileged. So please don't make any statements that you would not want the whole world to hear. Okay, sir? So, Mr. Florio, I've told you preliminarily what I've decided. I'm presuming that you understand the charges, or would you like for me to?
I do.
Okay.
No, sir, Your Honor. We actually received the warrants previously. Mr. Bailey and I had a chance to review the warrants. We've reached out to the alleged victim in this case and have actually been working towards trying to resolve this. Mr. Bailey obviously made the decision to surrender himself to the jail last night with our intention of appearing for first appearance this morning.
Right.
Judge, I'm prepared to address the warrants if the court would allow me.
Sure.
Judge, so the warrants, on the face of the warrants, the allegations are absolutely completely misleading. And if you were to read the language in the application does not match the language in the warrants itself. So Mr. Bailey's father has already been arrested and made bond for hit and run because his father was the one who actually drove the automobile. And the warrant alleges that, makes that allegation. The warrant itself does not, but the warrant application does. The warrant application alleges D. Bailey, who is Mr. Bailey's father, drove the vehicle through the drive-through and struck the side of the building, ripping a large section of the awning down, causing approximately $3,500 in damages. After striking the building, the two switched seats and T. Bailey drove off from the scene. So that's the allegation. Now, I've spoken with the owner of the business, and essentially the allegation is that his dad drove a box truck through a drive-through at a business here in Jonesboro and accidentally sideswiped the side of the building when he's going through the drive-through to pick up food. That's the allegation, Judge. And I've spoken with the owner of the business, Mr. Lewis, and I'll state in my place as an officer of this court that the alleged victim has indicated to me that Mr. David Bailey, the father who was arrested and is out on bond for hit and run, that Mr. David Bailey drove the truck through the drive-through, struck the building, got out of the truck, and then contacted Mr. Takari Bailey. I believe that to be true because Mr. Takari Bailey was in my office meeting with me on that other case that the court referenced when he received the phone call from his father about the accident having occurred. And so Mr. Takari Bailey left my office, drove down Main Street over to the restaurant. And Mr. Lewis, the alleged victim, identifies that at that point, Takari Bailey did show up. I believe they left the scene at that point, but I believe they left the scene only because they didn't have insurance information and they actually drove to their home to get the insurance information. Mr. David Bailey returned back to the scene with the insurance information, and that's when he was arrested for hit and run, and warrants were issued for Mr. Takari Bailey also for hit and run and criminal damage to property. I guess it's a theory of party to the crime of hit and run and party to the crime of criminal damage to property. I mean, I think that's the idea as it relates to Mr. Takari Bailey, because in the application itself does not allege that Mr. Takari Bailey actually hit anything. or that he actually caused the damage. The only allegation is that he drove the truck away, but we know that the purpose of that was to get the insurance information, because as I stated, Mr. David Bailey returned back to the restaurant, and at that time was he himself arrested. And so that's one of the reasons why we've been working candidly to try to get these warrants dismissed, because I think that there's significant legal issues with each of them. And obviously our efforts were unsuccessful. And so at that time, that's when Mr. Takari Bailey made the decision, the wise decision, obviously, to surrender himself to the jail last night for execution of these warrants. And so I understand that on their face, the warrants are troubling, certainly when Mr. Takari Bailey is on bond. I understand that. But I do believe that the language in the warrants itself does not match the language in the warrant application. And so I think that the language in these warrants, I don't know why Deputy Hunter said that he drove a vehicle when, the language is that he said accused operated a motor vehicle, which was involved in an accident, failing to immediately stop or remain at the scene. I think that's misleading because he didn't drive the vehicle. And we know that because Deputy Hunter's warrant, or the application for the warrant, states that. And so, Judge, we would ask that bond be set for the criminal damage to property charge. Again, I presume it's a party to the crime sort of a theory, but I just don't think that Mr. Takari Bailey did anything. And so we would ask that bond be set in this matter. I'm familiar with the other case, Your Honor. The other case involved a co-defendant. It was a traffic stop. Mr. Takari Bailey was the passenger in the vehicle in that traffic stop. And I believe that the drugs were located in close proximity to the driver. Both the driver and Mr. Takari Bailey were arrested because the driver did not claim ownership at the time. But that's the allegation in the other case. And I think Mr. Takari Bailey and I feel very comfortable with the facts of that case as well. I've had an opportunity to meet with the co-defendant, and I believe ultimately Mr. Takari Bailey will be exonerated of those charges in that case.
And what's the name of the father?
What's your dad's first name, Takari?
Demetrius Bailey.
I apologize, Demetrius, Judge. I apologize. I thought it was David. It is Demetrius. And if you'll give me a second, I can give you the WA number, the warrant application number.
Okay, that's what I'm looking for. If you can find it, that'll be perfect.
He is going to be. What's your dad? It's going to be.
Is it Demetrius O'Keefe?
Yes, sir. It's March 4th of 2021. And so his father was arrested, and which is going to be the date alleged in these warrants, Your Honor. His father was arrested for hit and run, striking a fixed object, and criminal trespass, damage to property. And I apologize, Judge. It is Demetrius Bailey. I don't know where I got David from.
Fine.
That's why Mr. Bailey was looking at me like I was an idiot. And he was arrested on a warrant application, obviously identifying that he was arrested at the scene and not on a warrant at a later date.
Right. Okay. Okay. I'm going to accept your representation, Mr. Florio, but I'm going to set a $10,000 total bond.
Yes, sir. Thank you, Your Honor.
$5,000 on each count. And given what I've seen and I've observed, I can accept your representation as it relates to the investigation that did or did not occur in this case. Mr. Bailey has a significant criminal history. But for having Mr. Florio here, Mr. Bailey, you would be sitting without bond at this time. Because you're on bond, and I understand the representation that Mr. Florio has made, but you have to understand, sir, being on bond, you're not treated the same as people who are not on bond. And there are significant limitations to your actions, or I wouldn't say limitations. There are things that can occur based upon your behavior because you're on bond that may not occur to the general public when they're not on bond. So you may need to take that into account in the future. He's going to have a preliminary hearing date set for July 28th. Of course, that date will get waived upon his bonding out. And he'll receive a new court date in the mail. Is there anything else, Mr. Florio?
No, sir, Your Honor. Thank you for that consideration.
You're welcome. Mr. Bailey, you're free to go back. Mr. Florio, you are free to go.
Thank you very much, Your Honor. Have a good day, sir.
You too. Okay, let's deal with Miss, let's switch over to the ladies' side and Miss either Dent or Jones. And
Good morning, Your Honor.
good morning. So I assume your client's married name is Jones?
That is correct, Your Honor.
Okay. And I'm sorry, it's Mr. Schrade.
Schrade, that's correct. Long A, one syllable.
Mr. Schrade, I have preliminarily set a bond for your client at $5,000. Actually, you know what? It should be $3,000 and not $5,000. But as I explained to Mr. Florio, I always allow the lawyer to tell me whatever they want me to hear about their client. Ms. Jones, you should understand, ma'am, that I would normally address you, but I'm going to address your lawyer because you've taken the opportunity to hire a lawyer. If there are any statements that you make during this proceeding, you need to understand that they're not privileged. So please don't make any statements that you would not want the whole world to hear. Okay. Okay, Mr. Schrade, go ahead.
Thank you, Judge. I'm not sure what exactly you have in front of you, but I think that you need to be aware very briefly of the history. Mr. and Ms. Jones are in the process of getting divorced. They share a child together. I don't know whether the final hearing has been scheduled. I don't represent Ms. Jones in that. I believe that it has been, but I can't state that for certain. Your Honor, this is the latest in a series of events that have been started by Mr. Jones. Mr. Jones caused a warrant for Ms. Jones to be issued in Henry County that was dismissed at the first appearance. The state dismissed that warrant at first appearance. It was not a preliminary hearing. I mean, it was such.
And that was something from earlier this year, correct?
That is correct, Your Honor. But again, that was dismissed. The minute a prosecutor put their hands on the warrant, it was dismissed. There was a TPO action that Mr. Jones brought against Ms. Jones in Henry County that was denied at the hearing. All of those things have happened, I want to say, within the last 45 days. I can't swear, but it's all been very, very recently, Your Honor. I understand that there is a video that Mr. Jones alleges to have that Ms. Jones grabbed him by the wrist. I've not seen the video, but given the rather significant history of Mr. Jones really just coming after his soon-to-be ex-wife unsuccessfully and on paper thin allegations, I'd ask for the lowest bond that the court could get to. Now, I understand that this is probably charged as a family violence, which means that we can't have unsupervised judicial release. I get that, Your Honor, but it seems to me that a $1,050 bond is probably the way to go. I can't tell you that I think that $3,000 is patently unreasonable, but you know, this lady is having to pay me to be here. She had to pay me to be at a TPO hearing. She had to pay me to be at a previous first appearance hearing, all of which came to naught. And I just ask that we keep the cost to her as low as possible, Judge.
Well, I'll tell you this. upon reading the warrant, it does look like this is a criminal case attached to um, other proceedings. I'll use that term. One of the things that I looked into as it relates to this case, for a simple battery, mainly the lowest I'll set is $3,000 bond. And that's just because simple battery generally involves pushing, shoving, that kind of stuff. You know, battery is punching, leaving marks. Your client has a significant criminal history. And one of the things that I look at as it relates to simple battery, criminal trespass, those types of offenses, those are things that are within your control. Like I can decide whether I take the cell phone out of your hand and throw it on the ground. I can decide whether I want to engage into an argument or a fight with you. I can decide those kinds of things. It's not a situation where I'm being goaded into pushing or that kind of stuff, right? Because we all have self-control. And in the context of being in this scenario, let's say that she's gone through this situation before in Henry County, and she was charged and the charges were dismissed. It would seem to me at some point that the light bulb needs to come on that I need to change what I'm doing, or I'm going to continue getting arrested. I'm going to continue having to hire a lawyer to come and advocate on my behalf. I'm going to continue having to do certain things. I'm not opposed to reducing the bond. I'm just trying to let you know where I'm coming from so we can have a discussion about it, because as a judge, I would prefer for law enforcement to be out there getting the people who are kicking in doors, not refereeing fights between adults or disagreements between adults that really don't have to involve law enforcement. Does that make sense to you?
That's directed at you, Jessica. It certainly
No.
makes sense.
I'm not.
Oh.
I'm talking to you.
I'm sorry.
No,
I apologize. No,
I'm not. And just so you know, I don't. I love when lawyers are here because I can have this conversation that I would never have with your client, because I'm a defense lawyer also. So I don't want people making statements trying to get themselves out of one situation and they open up another door.
Yeah, get into another. Your Honor, that makes perfectly good sense. I'd only note parenthetically that while there are previous allegations, and my client's criminal history is not insignificant, I don't disagree with any of that. And I think that you probably already take a note of the fact that, you know, the previous warrant was dismissed at the very earliest chance that it possibly could have been. It sounds to me like you're going to consider favorably my request to lower the bond, and I'm going to hush now before I say something that gets me in trouble.
Well, I'm not there yet, but
Okay.
I'm saying when I read what I have before me, essentially, it looks like this was either an exchange of custody, or there was something related to the child. To me, it's always it's something to take note of that her husband's father was there with a video camera videoing the event. But as a lawyer, I would advise my client, if you're having these situations, have the custody exchange at a police department. Have someone else, have your own person there videotaping. Because these types of situations should not be resolved through the criminal court process. And go ahead.
I'm sorry, Joe. No, I was going to say, I absolutely agree. Your Honor, I'll note parenthetically that the child lived primarily with Ms. Jones. There is not an interlocutory order in the divorce, but the way that the case had been proceeding, the child lived primarily with my client, with Ms. Jones, during most of the pendency of the divorce. Mr. Jones used the opportunity, the TPO, which was subsequently denied at a plenary hearing, to gain custody of the child on an ex parte basis. Since then, even though the TPO was denied, he has refused to give Ms. Jones access to the child and has been using the child essentially as a cudgel against my client. Now, you are correct that this incident which took place wasn't an attempt to exchange the child. I'd suggest to the court that given the recent history between the parties, it's not too much of a reach. And I wasn't there. It's not too much of a reach to suggest that Mr. Jones set this up, apparently his father, I didn't know that. I thought that it was Mr. Jones videotaping it. There with the videotape, acted provocatively in an effort to get Ms. Jones to do something like touch him on the wrist so that he could have another warrant taken out against her and have her put back in jail. The idea being that when they go to have the final custody determination, he's going to say, look how many times she's been arrested. I think it's a stone cold setup, but again, I wasn't there.
Well, see, and that's the thing. It could be, as a judge, I have to look at that. It could be, or it could not be.
May I intervene? May I say?
Ma'am, no, ma'am. You're not going to help yourself. You are not going to help yourself. Okay. But I'll use that as an example, Mr. Schrade. As a judge, sometimes you say, well, maybe I need to save this person from themselves. That no matter what the court does, the person is going to decide that they're going to do it their way. And if that's your client's position, she's going to continue to be before judges until the light comes on that maybe her way of doing things is not the best way. And so that's the thing where the benefit of having you here is I can have this conversation and that she can hear this. What I'm going to do, I'm going to reduce the bond to $1,500.
Thank you, Your Honor.
I'm going to place a stay away provision on the bond to stay away from Mr. Jones. I don't know what's going to happen as it relates to the process with the child, but that process is ongoing.
Your Honor, I'm
yes,
sorry.
Sir. No,
I was going to
ahead.
say I appreciate that the consideration, and I'm not carping about the stay away clause. I know that the standard language is no contact means no contact means no contact.
Yes, sir.
What I'd like is if the court's so inclined to have a
cannot
provision.
do no violent contact.
No, what I'm
Okay.
saying is that they be allowed to have contact, perhaps through an intermediary, to arrange for exchange of the child. In other words, can the terms of the bond be such that Ms. Jones can have contact with Mr. Jones for the purpose of exchanging the child? Because an ordinary no contact bond would mean that you can't communicate at all, even through a third party.
If there is an order in place as it relates to visitation,
there is not.
Then that needs to happen. See, and this is the thing, so that you understand from the judge's standpoint, once they're out of my view, they're out of my view. If they had done things in the proper manner, there would be an order in place. And so she would have the ability to see the child or whatever, because those issues are in place. I can't manage their whole life through this criminal case. So to the extent that she wants to have visitation with her child, she needs to get on the ball as it relates to the divorce and whatever they have in place. And that judge can enter whatever order the judge wants to enter. If this is something that this is just, and it sounds like this is possibly not going to happen, they can go through the solicitor's office, which happens all the time. And I'll tell you the reason that this is in place while we've gone away from the no violent contact or trying to enter into certain orders to kind of meet everybody in the middle, is that I don't know your client. All I know is there is obviously bad blood between your client and her soon-to-be ex-husband. And to the extent that I issue orders that allow contact between them, if they're not going to take the appropriate steps, all that's going to do is lead to something bad. That's just from our observation. Because if this was something that was really a burning issue to get taken care of, it would have gotten taken care of before now.
I understand, Judge. Again, and I don't want to carp too much because I like the way this thing is going. But can you include a provision, perhaps other than allowed by an order of the Superior Court of Henry County? Can you do that?
So no, and this is why. These types of hearings, I've been asking for us to have a district attorney or solicitor appear, so there can be a more full vetting, both sides being present. Any judge that that this is dealt with in Henry County, that judge will have both parties present. Judge will have the ability to consider everything. You will have this warrant, and it basically says that your client allegation, and understand this, Ms. Jones, this is just an allegation. The allegation is that your client was upset that her husband would not let her hold their child. He was walking away, holding the child, telling her to get away from him. She grabbed him by the arm, shoulder, and neck, trying to stop him from walking away, telling him to let her hold the baby. And the officer says, I observed the offense on cell phone video filmed by David's father, Don Jones. The offense occurred at the Lovejoy Regional Park in Clayton County, Georgia. So I would liken this to the situation where there is a, the TMZ stuff, a celebrity is walking out of the airport and there's the person with the camera trying to get the person to say something, do something wrong. Person sees the camera and punches the person anyway. And then says, well, they were bothering me. And yeah, I know it's on camera. I know and for me, it would be like, hey, you're a celebrity. You see the camera, the person is trying to goad you. You punch the person anyway. There's some level of self-control that has to come in at some point to say, okay, I see this. I see your dad has the phone. I see your dad is recording. I'm not going to get myself back in this situation. I'm going to step back. I'm going to call my lawyer. I'm going to tell my lawyer what happened. We're going to deal with this in the appropriate way. That makes a judge sleep better at night. That makes a judge feel that I'm not going to get a phone call that someone is dead and I wrote the bond and I didn't take appropriate steps. And I listened to Mr. Schrade say his client is like, nothing is going to happen. And then all of a sudden, this takes place. And I know it seems to be a little bit alarmist. And ma'am, I don't believe that you're going to go out and do anything of that nature. But my job is to try to protect you and the community. And that's where I hope you hear me saying that I'm trying to help you not make poor choices so that you have a long history with visitations every weekend, whatever, as it relates to the divorce case with your child. And you're not in a situation of saying, man, I wish I had not done that. Because as your lawyer has artfully laid out, worst case scenario is you're being set up where you're not going to have custody of your child. And to the extent that you don't see that, that may be an issue. So your lawyer has done a great job. He's walked me down from $5,000 to a $1,500 bond. Stay away provision is going to stay in place. Please be in contact with your lawyer. And I wish you the best. Her preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That date will get waived upon her bonding out, and she'll get a new court date in the mail. These conditions can be modified. And from the court's perspective, if there's a modification that takes place, it's best that all parties are present so that this can be fully heard. Okay?
I understand, Your Honor. Your Honor, I appreciate the court's time and consideration. I feel like my client got a fair shake, and I appreciate it, Judge. Thank you.
Thank you. You're free to go. Miss Jones, you're free to go back, ma'am.
Thank you,
Thank you,
Judge.
Judge. Have a great day, Judge.
You too.
Bye-bye.
Goodbye. Okay, let's continue on the ladies' side. Miss Hunley? I'm sorry. No, I'm sorry. Sorry. Miss Hunley is a fugitive. Miss McCready?
Yes, sir.
Okay, ma'am. You are charged with 1 count of criminal trespass, damage to property. It's being charged as a felony. Nope, sorry, misdemeanor. The bond is going to be set at $4,000. Do you believe you can post that bond, ma'am? Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out. Yes, ma'am. I'm sorry, do you have a question for me, ma'am? Okay, ma'am, you're free to go back. Tell me your name, ma'am.
Katisha Fenn.
Ms. Finn, you're charged with 1 count of simple battery, 1 count of criminal damage to property in the 2nd degree, 1 count of battery, and 1 count of terroristic threats or acts. I've set a total bond at $18,000. Do you believe you can post that bond?
Not 100% yet, but I'd have to get in contact with someone, so.
Okay. There's going to be a stay away provision on the bond and stay away from Michael Long. Do you understand that?
Yes.
This is being, the criminal damage to property in the 2nd degree and the terroristic threats are being written as felonies. So you're going to have a preliminary hearing date set for July 28th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
Okay. All right, ma'am, you do qualify. I'm going to appoint a lawyer to represent you.
Okay.
Do you have any questions of me?
Yes, so how would that go? They will just contact me here or?
I'm sorry, I can't hear. Say it again, ma'am. It was the background noise. It wasn't you.
Sorry. Okay. I was asking if they would contact me or the fact
As to the court date?
As to the court date, yes, the lawyer.
Yes, ma'am. The address that you give to the sheriff's department, that's going to be the address that any notices are sent to.
Okay.
So if you're not going to be at that address, you need to put in at least a change of address with the post office for that address.
Okay.
And when you have an updated address, you update the address with the court system.
Okay.
Your case is going to be in Superior Court. So it will be with the clerk of Superior Court that you would have to update your address and the district attorney's office.
Okay.
Okay. Any other questions, ma'am?
No, that's it.
Okay, ma'am, you're free to go back.
Thank you.
Let's see. Miss Riggins.
Yes, Your
Okay, ma'am, I'm dismissing these charges against you. However, you need to understand that the obstructing an officer charge was really, it just wasn't there. The contributing to the delinquency or deprivation of a minor in a criminal trespass, those are close calls. Whenever you lock someone out of a place where they live, that can be criminal trespass. However, it appeared that it was saying that your 13 and 15-year-old daughters are coming home at 2 o'clock in the morning.
Yes.
Okay. So in the future, ma'am, that is basically they're being unruly, and you can contact either juvenile court or the police department to report your children as being unruly. Taking the steps that you've taken will almost 100% lead to your being arrested. Okay, are we clear?
Yes, Your Honor.
Do you have any questions?
Um, what does dismissing mean?
It means that when this paperwork get processed, you're going to get released.
Thank you, Your Honor.
You're welcome. You're free to go back, ma'am. Ms. Williams,
Yes, Your Honor.
ma'am, you're charged with one count of simple battery. I've set the bond at $3,000. Do you believe you can post that bond?
No, Your Honor. I'd have to call my mom probably back in California.
Okay, would you like for me to see if you qualify for the appointment of a lawyer?
Sure.
Okay, ma'am, you do qualify. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions for me?
Is there any way we could lower the bond amount? I'm the only person in Georgia at all in my entire family. Like I'm here by myself.
No, ma'am, this really should have been drawn up as a battery, not a simple battery. The allegation is that you threw a cooking pot and hit the victim in the back of the head.
Okay.
Oh, there's going to be a stay away provision too on it to stay away from Jamal Jackson. Do you understand that?
Yes, sir.
Okay, ma'am, you're free to go back. And Miss Hunley.
Hi, Your Honor.
Ms. Hunley, ma'am, you are here as what's called a fugitive from justice. And what that means is that you don't currently have charges pending in Clayton County, but you're being held on an allegation that there's a warrant for your arrest out of Berks County Sheriff's Office for theft by deception and forgery. Have you been explained this process?
Just a little bit. I have these papers to file.
Okay, so you have a right to contest the extradition. And what that means is that you have a right to demand a hearing. And sometime probably within the next 30 days, there'll be a hearing to determine whether you are the person named in the warrant and whether the warrant is in fact a valid warrant. We have no interest as to whether you're guilty or innocent. Those are the only issues that we will be determining. If at the end of that hearing, we determine that you are the person named in the warrant and that the warrant is valid, extradition will be signed, and then the jurisdiction has up to 60 days to come get you. If you believe you are the person named in the warrant and you believe that the warrant is valid, you can waive that hearing today. And if you waive that hearing, that up to 60-day period begins to run today. Do you have a lawyer representing you?
No.
Okay. Have you ever had a lawyer representing you on these charges?
No.
Okay. Do you have any questions of me so far?
Just a small question I have. If I was to sign this paper, that you guys could only hold me for 10 days until they come and get me?
No, that's not true. It's a 30-day period minimum that they have. If they don't come in to get you within that 30-day period, the sheriff's department will contact the requesting jurisdiction and say, hey, are you going to come get this person? They can either say no, or they can request an extension. If they request the extension, then you'll wait another 30 days. If at the end of that 30-day period, they don't come and get you, you will get released out the front door. But that doesn't mean the warrant has gone away. So if you're released out the front door, 5 minutes later, you encounter another law enforcement officer, they run your information, the warrant is valid, the whole process starts all over again.
Mm-hmm.
So I don't work within the fugitive department over there at the sheriff's department. They're the ones that have had contact with those individuals. They may have said, "Hey, we'll come and get her." I don't know. I had a situation yesterday where the detectives from New York were already here waiting. So when the person signed the warrant, that person was sent off that day. So because I'm not the person making those determinations, I can't tell you, yeah, they're going to come and get you in 10 days, 5 days. It could be 2, it could be 30. They could request an extension. But while you're sitting here, you're just going to be doing time.
And
So that's why I say,
that
if you know,
that
so
was
that's why
their time. Like
I'm
it'll
sorry.
be time served. When they finally come get me, it'll count as time served.
I can't tell you that. Ma'am, you're asking me to tell you what somebody else is going to say in another jurisdiction. I don't know. All I can tell you is that if you know you're the person named in this warrant, and if you believe that these charges are valid, while you're sitting here in Clayton County, nothing is going to be being done on your case up in wherever it is. And so at some point, if you are the person named in the warrant and the warrant is valid, you're going to go back to that jurisdiction. So it can be slow or it can be fast. But while you're sitting here, you're just doing dead time.
Okay, and the time doesn't matter. Is that what you're saying? The time that I'm doing here, it doesn't matter, or?
Ma'am, this is what I'm saying. I'm not a lawyer or a judge in that other jurisdiction. I don't know how they calculate time.
Okay.
I know if you were a person being held in another jurisdiction in another state and you're being held here for Georgia, that time doesn't necessarily count. Because if you're fighting it up there, you're the person that's keeping you up there, not the state of Georgia. If the state of Georgia says, "Hey, we want her today," and you say, "No, I'm going to fight it," you're the person that's doing the fighting, not the state of Georgia. Does that make sense to you? So it's up to you. If you want to have the hearing, I have no dog in the fight. My only obligation is to make sure that you understand what decision you're making and why you're making it.
Okay.
So do you know what you want to do?
Yes, I do.
Okay, what do you want to do?
I signed the extradition.
Okay, you sign the waiver. They're going to give me the paperwork, and then the clock will begin running today. But I would encourage you, to the extent that this other jurisdiction, the sooner you get a lawyer up there to represent you, the better off you're going to be.
Okay.
Okay?
Okay, thank you.
All right. Once you sign the waiver, ma'am, you'll be free to go back and they'll send it to me.
All right, thank you.
You're welcome. Okay, let's switch over to the men's side. Okay.
Honor, I have a question for you real quick.
Yes, sir.
I have a Mr. Barnes. I had a CAA sheet on him, but he wasn't on the first appearance. I went ahead and pulled him out just in case.
So he's not on the list that I got from the sheriff's department. I do have a warrant. I'm sorry, a bond, but I don't have the warrant. And a lot of times his charge is one that is immediately bondable. And so a lot of times what that says to me is that he may have already posted bond. So let's bring him up and see if he knows where the bond has been posted or not.
Okay, we'll go ahead and start with him then, sir.
Mr. Barnes.
Yes, sir.
Sir, do you know if your bond has been posted yet?
I know my father should be up here trying to post it.
Okay. So what it appears, because it takes this whole process has been going on since early this morning. And so your case is one where your bond is immediately bondable. And so when I get paperwork the way that I see it and you're not on here, what that tells me is that you've probably your bond has been posted and your paperwork is now in the bonding area. So if you want, I can make a determination as to whether you qualify for the appointment of a lawyer since you're here.
Okay.
All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. And so that's at least one benefit that you get from being here. But I do believe that your bond has probably already been posted.
Okay, thanks.
Okay, you're free to go back.
Mr. Burris?
Go back.
Yes.
Mr. Burris, sir, you're charged with 1 count of violation of Georgia Controlled Substance Act and 1 count of possession of firearm by a convicted felon. Bond is going to be denied at this point on both of these felony offenses. You're going to have a preliminary hearing that's going to be set for July 28th at 8:30 in the morning. I'm also going to set a bond hearing date for July 30th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, so you're free to go back.
Mr. Daniel?
Mr. Daniels, sir, you're charged with 1 count of battery and 1 count of aggravated assault by strangulation. I can't set the bond on the aggravated assault by strangulation charge, but I have set a bond of $5,000 on the battery. There's going to be a stay away provision on the bond to stay away from a Takia Brown. Do you understand that? You're going to have a preliminary hearing date set for July 28th at 8:30 in the morning. You're also going to have a bond hearing date set for July 30th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. I got a bond for the battery, but not for the aggravated assault.
Right. I cannot set a bond on the aggravated assault by strangulation charge at this hearing. Okay. Any other questions?
No, sir.
Okay, you're free to go back.
You're gonna have to say your name. L. Amin?
Okay, Mr. Elamine, sir, you're charged with 3 driving-related offenses. The bond has been automatically set on these offenses, so you're going to have a total bond of $3,000, which is going to be a little bit higher because they're going to have to add fees to this. Do you believe you can post this bond?
Not at the moment.
Okay. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. Are you currently working?
No, I was working.
Okay. All right. You do qualify, sir. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. The date will get waived if you're able to bond out. I would encourage you to contact the bonding companies because they will work with you in getting a bond. Do you have any questions for me?
If I don't qualify for the bond at the time, when I will have to wait till July?
No. With offenses like this, if you can't make bond, they'll put you on a Monday jail calendar and try to resolve your case.
Okay.
Okay. Anything else?
No, sir.
Okay, you're free to go back.
Mr. Hernandez?
Mr. Hernandez, you're charged with 1 count of public indecency. The bond has been set at $2,000. Do you believe you can post that bond?
Yeah.
Did he say yes?
He said yes, Your Honor.
Okay, your preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, sir, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Is it Lachi? Okay, sir, you're charged with 1 count of driving a vehicle without a valid license. The bond is automatically set at $1,000. Do you believe you can post that bond? You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? All right, you're free to go back.
What's we got for lunch? Siegel?
Okay, Mr. Siegel. Sir, you're charged with 1 count of theft by shoplifting and 1 count of violation of Georgia Controlled Substance Act, possession of a controlled substance. Because there's an indication that you're on probation, I cannot set bond for this offense, for the felony offense at this time. I have set a $2,000 bond for the theft by shoplifting. There's going to be a preliminary hearing date set for July 28th at 8:30 in the morning. The date will get waived if you're able to get a bond. And just so you know, I cannot set bond at this hearing. It does not mean that you can't get a bond tomorrow or after that, but it has to be something where there's a time for your probation officer to be notified of this arrest. I'm going to set a bond hearing for July 30th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes. So will y'all, how soon will y'all be getting in touch with my probation officer, my parole officer? I'm on parole.
You should be getting in contact with your parole officer if you want to get out as quickly as possible. If you're waiting on someone to contact your parole officer, you may be waiting.
Okay. I mean, so saying like, once my wife get in touch with my parole officer, how soon can I get the bond?
Okay, so I'll explain the process to you.
Okay.
So right now, because you're on parole, the district attorney would have to consent to a bond, or you would have to have a bond hearing. If you wait for a bond hearing, that's going to be July 30th. If you're trying to get the district attorney to consent to a bond, then someone is going to have to put the information before the district attorney for them to make that determination. The district attorney is not going to be staying up to midnight trying to contact your parole officer to make a determination as to whether they're going to let you out on bond or not. Does that make sense to you?
Yes,
If it's important to you to get out, you're going to have to take those steps. If you're just going to wait for somebody else to do it, you're probably going to be sitting in jail until July 30th.
Yes, sir.
Okay?
Yes, sir.
Any other questions? Okay, you're free to go back.
Apologize. I meant to say DA. Senior, senior or senior? How do you say it? Senior, okay, senior.
Okay, sir, you're charged with 1 count of criminal trespass. The bond is going to be set at $3,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision, a stay away from, and I could barely read the handwriting, but it looks like Khadijah Cornmont. Do you understand that? Your preliminary hearing date is going to be set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir, you're free to go back.
Stolen.
Okay, Mr. Stovall, sir, you've been charged with a number of driving-related offenses. All of these are misdemeanor offenses. Is it okay for me to just add up the total amount of the bond? Or do you want me to go through each one individually? Okay. Your total bond is going to be set at $8,000 for these 8 offenses. Do you believe you can post that bond? There's going to be a preliminary hearing date set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? Yes, no?
Yes. Yes.
Okay. All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Proceeding.
Siegel? Huh? Come on, Taylor. Mr. Taylor?
Okay. Mr. Taylor, sir, you're charged with 1 count of battery and 1 count of criminal trespass. I set a total bond of $8,000. Do you believe you can post that bond? You're going to have a preliminary hearing date set for July 27th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. There's going to be a stay away provision on this bond, stay away from an Andrea Dawson. Do you understand that? Would you like me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, sir, you're free to go back.
Mr. White?
Mr. White, sir, you're charged with 1 count of terroristic threats, 1 count of criminal damage to property in the 2nd degree, and 1 count of simple battery. I've set a total bond of $13,000. You believe you can post that bond? You're going to have a preliminary hearing date set for July 28th at 8:30 in the morning. If you're able to make bond, that court date will get waived. You will get a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me? Okay, you're free to go back.
Wilcox?
Mr. Wilcox, I've looked over your warrant. You're charged with 1 count of aggravated assault by strangulation. And there was some additional information that I was trying to find as it relates to your warrant that I have not gotten yet. It doesn't look as though I can set bond on this offense because you're on bond already from an April 16th arrest of this year for criminal trespass and simple battery. And this occurred after that arrest. So I'm not going to be able to set bond for this offense at this time. I'm going to set a preliminary hearing date for July 28th at 8:30 in the morning. I'm also going to set a bond hearing date for July 30th at 8:30 in the morning. Would you like me to see if you qualify for the appointment of a lawyer? You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Yep. And last we got, Magnus, I apologize.
Okay, Mr. Magnus, were you able to hear the prior discussion as it relates to the
Yes, Your Honor.
fugitive? Okay. Have you had an opportunity to think about whether you want to waive the hearing or have the hearing?
Yes, Your Honor.
And what is your decision?
So, waived it, right?
Yes.
Yes, I waived it.
Okay. Do you have any questions for me, Mr. Magnus?
No, sir.
Okay, once you sign that, you'll be free to go back.
All right, I got him, Your Honor.
All right, thank you.